I would say one other aspect to take into consideration is not even litigation or pre-litigation, but hey, we were able to successfully resolve your case and you are going to get that repurchase. That too takes time. People don't realize it, but repurchases do not happen the day that you accept the settlement.
Welcome back to Lemon Law Unpeeled, the Lemon Law podcast. I'm Emma.
And I'm Courtney.
And I'm Steven.
And today we're going to be talking about how long does a lemon law claim take, which is kind of a tough topic, right? Because it really varies. It really depends on the case and really depends on who the manufacturer is. Just broad strokes looking at it, there is one manufacturer that sticks out, I think, in all of our minds as taking the absolute longest to get anything done. And I think we all can agree that it's Chrysler at this point. We get a lot of cases settled with them, but it's anywhere from like 4 to 6 months sometimes with them.
Yeah, that's totally true. And one pattern that I've noticed is once a vehicle is fixed, they take a whole lot longer to answer. So the vehicles that are still sitting out of service, unrepaired, they tend to get back to me faster. And I still wouldn't say fast, but faster. But I have another case where the vehicle's been fixed for months and they have just been dragging their feet. I think it's about 8 months that we've been waiting. We hesitate to file suit because the vehicle is fixed. The client doesn't really want to file suit anyway. And Chrysler's rep keeps telling me, real soon, I'm almost done, I'm going to hear back any day, but it's been taking forever.
I would say one thing that also adds to the frustration with FCA is they, unlike other manufacturers, will parse out their work to firms that are outside and not internal departments like General Motors does. So you're dealing with a different firm based on the region that you're dealing with or what state you're dealing with. So some firms are a little bit quicker to respond, whereas other firms take forever. So it's kind of a crapshoot, quite honestly, on which way and how long it's going to take, possibly just based on which law firm we're dealing with for FCA cases.
Right, because we have FCA in Ohio or FCA in Colorado. They'll get us an offer usually within 60 days. And then we have FCA in New York, New Jersey, PA, which is all the same firm. And that's the firm that can take, I say on average, 120 days. And I don't know what their internal process is. I know it can be a mixed bag of factors, right? Like Steven, you and I, that case that we just had where the car's been sitting at the dealership since July, I think at this point. And the client tells us, I talked to the dealership. They can't fix it. It's not a fixable problem. FCA or their, representative from the law firm talks to the dealer and tells us there's nothing wrong with the car. The client just abandoned it. And so we're sitting here who's telling the truth? What's going on here? And then all of a sudden we get some message that engineering recommended a fix for the vehicle. The truck is ready for our client to pick up now. And so it's what happened there? Why has this been going on for so long?
And it's difficult because the dealership may say one thing and we're hearing something else from the manufacturer. So clients getting a mixed signals well, do you guys know or does the dealership really know? And they don't understand that sometimes the dealership and the manufacturer are not actually talking directly to each other in a clear form of communication.
I've also had it before where Chrysler's been we've been reaching out to so-and-so at the dealership repeatedly. We're not hearing back. And I give that name to the client and the client's that person doesn't work there anymore. So we've definitely had it where it's just, like you said, that gap between a law firm and its dealers as opposed to being in-house where they have access to the repair orders, where they can get that information themselves is totally different. And I guess get that information themselves we use kind of loosely, right? Because it's just the warranty repairs. If they couldn't duplicate the problem, that's not going to usually be in their system in-house. It's just whatever they had to pay for. But it does expedite the process depending on who is handling the claim on behalf of the manufacturer. Is it an outside counsel or is it in-house where they have more of a direct line to the dealerships than a law firm calling them? Because we've definitely run into issues with that too. But then if we look also at Ford, right? Ford has outside counsel, but we hear within 30 to 45 days from their pre-litigation group. So what's the difference there is also the big question.
I think what helps with Ford is that they have just one outside firm. So we know exactly who the firm is, whether it's Tennessee, the East Coast, out west in Colorado. It's just the one firm. We can reach out to them. For example, though, FCA in Georgia, Sometimes we're not sure if it's an outside firm or if it's Stellantis themselves, because sometimes for some reason they will have in-house handle it, and sometimes they'll parse it out to an outside counsel. So we might have to reach out to them because they haven't told us who's handling the case. How can we even negotiate or try to resolve this case if we're not sure who we're dealing with?
So I think in the broad strokes is it really depends and varies. It can take us anywhere from 30 days to months to years to complete a lemon law case. But there's so many factors that come into it that determine how long it's going to take. Like we just talked about, who manufactured your car? Who handles their pre-litigation process? Do we have to go to court? That's a whole other can of worms. That's a whole other timeline that can come out depending on if we have to file the lawsuit and who is the lawsuit being filed against. The same thing too with manufacturers, right? There's some manufacturers where we file the lawsuit and we know we're going to get it resolved before we see inside of a courtroom. And then we have other manufacturers that make us take it all the way. And that can be a good or a bad thing, right? I've definitely had some cases, like for example, I think we talked about this case when we were talking about electric vehicles. It was a Ford case that was denied in pre-litigation. So we filed the lawsuit. That lawsuit lasted at least 10 months, I want to say. And that is, by New York standard, a pretty short lawsuit. And we did get the repurchase, but that was a case where basically our client had tons of proof of the problem happening, and Ford just wasn't doing enough to dig into it and figure out what the issue was. So we had a lot to support our demand for a repurchase. It's just pre-litigation looked at it and said, hey, listen, I don't think there's enough here. We're just going to flat out deny it. And we had to take it to court, take it to litigation in order for Ford to see, hey, there is actually something going on here and there is an issue with this vehicle. But that doesn't always happen. I've definitely gone to trial and lost. We've definitely taken cases for like a year and had the pre-litigation offer be better than what we ultimately end up in court. There's just so many factors that come into play with that.
Yeah, absolutely, especially if the issue becomes fixed during that litigation time period. So say we have a $5,000 offer on the table pre-litigation, client wants more money, so we file a lawsuit. But while we're waiting a year and a half to get to court, the issue becomes fixed. So by the time we're sitting in front of a judge or a jury, the issue's been fixed for 7-8 months. We're now looking at very likely losing, or even if we win, very likely getting less money than we had on the table pre-litigation. So that's always a factor.
Another factor once you file is you're at the mercy of how the judge wants this schedule to go out. So the court will issue a scheduling order, and judges want these cases to resolve. Preferably, they want to try to get this done without having to have time for a trial. Obviously, they will have a trial if necessary, but they will have settlement conferences, arbitration, mediation, anything to see if they can try to resolve it prior to that trial date. That can easily add a couple months to 6 months, depending on which court you're in, how busy the court is in. And also, there is a chain of priorities when it comes to cases. Judges will see criminal cases first if they handle both criminal and civil. That takes priority over any civil case normally because of what's going on in that criminal case. So there are a lot of factors within the courtroom and in chambers that you may not be aware of, but we can't control it because it's now the judge's discretion on how your case will be proceeding schedule-wise.
Yeah, I've definitely had that where a judge, we've either gotten pushed back, right? I had an attorney, so this is a wild story, and it's a lot of just circumstance, right? So it was a Philadelphia case that I had. It was a trial that we were on. And this was actually, wasn't necessarily lemon law. It was a new Vehicle Damage Disclosure Act case. So basically, we had a client who purchased a vehicle from the dealership and claimed that there was all sorts of paint damage on the exterior of the car at the time that she bought it and that they covered it up. And in Pennsylvania, if you have damage to a vehicle that amounts to over a certain percentage of the purchase price or a certain number, that has to be disclosed to the consumer. The dealership, of course, is saying, no, that's not true. There wasn't any damage to this car. We didn't do anything. But Chrysler, when she brought it in for warranty work or repairs, were like, this is due to outside influence. This damage is not our responsibility. So we filed against both the dealership and Chrysler in order to be able to try to get some relief for her. And we end up in trial. And it was literally the day before we were supposed to go, and their counsel said that he was sick, and they canceled the start date. So they canceled the start date. We show up the next day, and one of our big moments that we had in arbitration, because we were successful at arbitration, was their expert was trying to testify regarding paint damage, but he was a mechanic, right? There's a difference between working on an engine and being able to work on exterior paint body damage. So we actually got his opinion kind of kicked out because he was not qualified to talk about that. Lo and behold, we start trial the following day instead. And I just happened to be sitting there and get the defense counsel puts on my table a certification under ASC for body work and body damage that just happened to be certified to their expert the day prior. So I was like, what is going on here? Were you actually sick yesterday? Which he very well may have been. Like I said, this is a lot of circumstantial evidence, but it just so happened that all of those events came into play. So then we're sitting there at trial. And when I attempted to throw him out for his credentials like I did at arbitration, I was blocked because lo and behold, there is his ASC certification stamped from the day before. Now, again, could I use that against him, right? He's only been certified for a day as opposed to our expert that's been doing it for 20 years. Absolutely. But that was a huge just like shot to the foot that we weren't expecting that happened. We still were successful at trial, but things like that happen. Things like that you don't expect can really just appear or go into arbitration, and the defendant has some information that we don't know about a prior accident or some other damage that the client didn't tell us about that ends up just blowing the case up. And then we're kind of standing there like, well, we had a pre-lit offer of X. We probably should have just taken it. Now, obviously, these are like, individual case by case, but things like that do happen. Like you really have to sit and consider when determining, do we take this offer or do we go to litigation?
Yeah, absolutely. And it might not even be anything as dramatic as that, but maybe you just got in an accident with the vehicle while you were waiting for trial, and now the vehicle's totaled, and now our case goes out the window. Or just talking about the timing of trials, and sometimes a judge is going to push you back and push you back. I've actually even had the opposite happen, where the judge was frustrated, the docket was so full, and then he had a one-day opening here, and he knew we'd be quick, so he called us in the day before. Hey, you guys are going tomorrow. And I needed to call the client, and the client had to take off work, and we had to clear all of our schedules. And there you are. So you're really just at the judge's mercy for better or worse. And it can be really stressful. It can be really stressful on everyone, including our clients.
And then in recent years, obviously, we've all seen something very significant that has impacted everyone's case, the pandemic. So with that being said, no one had prepared for this type of situation. No one thought this was going to happen. That was an external factor that not only affected us, but affected the courts themselves. Everything got backed up. Everything got jammed up. No one knew how to address these cases because no one could be there in person. So, for example, I had a case in Maryland, 3 weeks away from trial. The pandemic happens. The case got moved a year for the trial date. So now everything has been done. Discovery is done. Motions are done. The case is sitting there for a year before we can have a trial. So fortunately, we were able to reach a resolution a month before that trial date. But that's just several more months where the client is saying, well, can't we do anything? No, unfortunately, the jury can't be there in person. We can't have a trial in person. Maryland had some very strict rules at the time. So we were kind of at the mercy of something that wasn't even the court's ability to address.
Yeah, and honestly, that's not even over. We're 4 years past the pandemic. I had a settlement conference last week where the judge actually said to us, hey, look, we're still super backed up. I've got a 5-year backlog because we are still feeling the effects of not being able to have trials for a year. So, yeah, I think long story short, when you file for litigation, when you're filing a lawsuit, we're in it for the long run.
We have a client right now. It's a case in New York. Amanda and I were just trying to reach them this morning because they traded in their vehicle, which is okay, right? Sometimes we can still get it resolved for that. They're just not responding to us. They picked up the phone this morning. Amanda said who she was, our paralegal, and they hung up on her. And it's like, we have an active lawsuit going right now. You can't just ghost us. You can't do this. I get that it's frustrating. I get that it's a process, but this is a commitment that was made. And we determined to take this route together. And now you're just leaving us with nothing. And that's really difficult too. And granted, like most of our clients are not like that, right? This is kind of the rare occurrence. But like you said, the frustrations with the length of time, dealing with the issues and all of that sometimes can just culminate in wanting to throw your hands up in the air and just not dealing with it anymore. But when you're in an active lawsuit, you can't do that. When you file a lawsuit, you are committed and you have to take it forward. You can dismiss it if at some point, but usually that dismissal is going to be with prejudice, meaning you cannot file it again if you change your mind 2 months down the road and want to restart it. We have sometimes been able to navigate dismissing it without prejudice, but we have to get the defendant to agree to that and to say, yeah, sure, we're going to let you just file another lawsuit against us if you want to, which again, that depends on the manufacturer, depends on the attorney handling. That's not always something that they're going to be willing to do. So it's really, really tricky when you're in this litigation when you decide to take that step. Another example I have is another case we have going on right now in New Jersey. Another client that I talked to, and I basically was explaining, look, your vehicle's just under 2 years old, and you've put 60,000 miles on this car in less than 2 years. I highly doubt any court's going to award you a buyback because you have to show a substantial impairment. If you put that kind of miles on a vehicle in 2 years, your vehicle's not substantially impaired. It's just not. The average person puts 10 to 12,000 miles a year on their car. You're putting almost 30. So we can't show that the impairment's so strong that you can't use your vehicle, you couldn't get from point A to point B. And it also really makes your whole argument that you don't feel safe in the car null because you're driving it and you're driving it excessively. So cash is the most likely only option that we have here. This is what our expert came up with. She doesn't want that. She doesn't want that. She only wants to repurchase. And we're sort of at the point where, yeah, we'll go forward with arbitration and see what they say. But it's sort of like, well, we're not going to be able to achieve that. You're kind of shooting yourself in the foot because, again, at court, they may not award our full expert number because of the miles you put on it. They may look at this and say, okay, so you've had a bunch of visits. I do agree that the dealership blew her off. She had a coolant leak and they were definitely ignoring it. But at the same time, they're probably just going to put a couple $1,000s on it. She won't let me negotiate for cash with them right now. She wants to just, move forward and let it play out. Or she's actually right now actively seeing if she can find another attorney to represent her and get her repurchased through different means, which I'm like, that's what Lemon Law is for. There is no other law that you can go under. And she just keeps telling me it's not fair. And it's sort of like we're stuck between a rock and a hard place because I can't foresee us achieving the outcome that she wants. And there's no other law that you can go under. So what you should do is just negotiate for the most money you can and take that and run with it, as opposed to kind of putting your neck on the chopping block when you're going to arbitration, trying to defend a case where you've got an excessive amount of miles in your vehicle in less than 2 years.
Yeah, absolutely. There's so many cases where we can get more through settlement than we can through arbitration, because a lot of times we can get the maximum cash by settling, whereas if we go to court, we can get anywhere from $1 to that maximum cash. So yeah, a lot of times we're going to be able to get more. Is it necessarily fair? No. And sometimes I see what our clients say. No, it might not be fair. It might not be equitable. It might not be what you want. But we're at the mercy of these laws. And a lot of times you really just have to take emotion out of it and make a business decision and not shoot yourself in the foot and not go to trial over principle. I know someone who used to say the only people who can afford to stand on principle are Warren Buffett and Bill Gates. And, there's some truth to that. I mean, the rest of us can't afford to stand on principle, right? You're going to shoot yourself in the foot. It's not going to end up making sense for you. And you're not going to go and feel vindicated by going to arbitration or going to trial. Most likely, you're going to end up feeling more frustrated than when you walked in.
I think that brings up a good point on before even filing litigation, there's a whole time frame that we're talking about for pre-litigation to try to see if we can get your case resolved successfully. So that also takes time on top of litigations.
Yeah, most of these cases, right, we've already tried the pre-litigation process, which step one is we send the manufacturer a letter letting them know we represent this client and we want to talk about their claim. Right? Even just submitting that letter and getting it processed, depending on who the manufacturer is, it can take 1 week to 4 weeks to get an acknowledgement, meaning they write back to us saying, hey, we got your letter. We're looking into it. Give us some time to review it and we'll get back to you. And then you enter the next set of timelines, which is how long is it going to take the manufacturer to complete their review and respond to us either with an offer or a denial. And that in itself can be anywhere from an additional, you already have that 1 to 4 week process, right? And then this is an additional 30 to, like we talked about, 30 to 120 days in which we're waiting on that. Plus, for a lot of clients, they've already been dealing with this issue in their vehicle for over a year. So you tack on the frustration that they've had already having to go to the dealership so much. Then you tack on the timelines for pre-litigation. Then let's say we'll take the average 90 days, right? We wait 90 days and they either deny it or they make an offer. And we assess the offer and we decide, hey, we think it's worth going to litigation. Then litigation itself, that's at least a minimum of 60 days for filing, serving it on the defendant, and then they have 30 days to file their answer, let alone actually getting to the point where we're negotiating. So litigation itself as a minimum is an additional 2 months. If not, I would say the average for litigation is probably 5 to 6 months that we're looking at as the shortest time frame. And then we have others that can take a year or more. So when you compile all of that together, that's a pretty long time frame, depending on what stage you decide to take your case to or that your case is deserving of going to. And that can be a really tough, really wide range of time that we're dealing with. So usually when we're assessing for litigation, when we have an offer, we look at it through the perspective of, is litigation going to benefit our client? Is it worth taking those risks and tacking on the additional time for what? Right? Are we going to be able to get the repurchase? Are we going to be able to get $1,500 more, $2,000 more? Is it actually going to be worth it in the end to take that additional time? Or is it ultimately, once you factor in the time and expense that the client has to put forth, and I just mean expense in terms of time off of work for a deposition, taking your car to the dealership and dropping it off for an inspection, attending an arbitration, attending a trial. When all of that gets added up, that probably is going to cost the client $1,500 to $2,000 more. So it's really a balancing act that we have to manage and navigate when determining what way to take the case.
Yeah, absolutely. And like we were saying, a lot of times we go to arbitration or trial and actually end up winning less than what we may have had on the offer as a settlement beforehand. I remember one time walking out of a Ford arbitration and our client had been awarded money, and I was speaking with opposing counsel who said, this is a win for me, even though he had technically lost because our client was awarded money, but he was considering the case a win because our client was awarded less than what he had offered the day before. So a lot of times, like I was saying before, you really have to take a step back, look at it as a business decision, and really think about whether it's going to behoove you to move forward or not.
Yeah, and some manufacturers, too, will litigate just to litigate. One of my favorite examples was a Nissan case we were litigating, and we were going into arbitration, and the defense counsel was like, you've got nothing. Like, we might as well move forward. I'm confident we're going to get a no cause. We go in, we're actually successful, and we do win a cash settlement for our client. And we walk out, and defense counsel was like, yeah, you had all the cards stacked in your favor. We knew that this was a winner. And it was like, what? What happened? You were just talking so much, crap about the case before we go in. It's like, again, they're just litigating to litigate, right? Because a lot of clients say to us, oh, the attorney's fees, the costs that it's going to take for the manufacturer to defend this case, they're going to roll over. They're going to pay it. That's not how they look at this. They're not going to just roll over so they don't have to pay their attorneys. That's not a precedent that they want to set, and that's not something that they're going to do.
Yeah, sometimes they're kind of making a stand like, hey, I'd rather spend the money and litigate this case than make a habit and set a precedent of just settling these cases. And other times, it's the law firm that's handling it. That's the defense counsel for these manufacturers. There's a law firm that I can think of right now, and Emma, I'm sure you're going to know what I'm talking about, that used to litigate everything. And I know for a fact that they were not necessarily giving their client, the car manufacturer, all of the facts. They wouldn't necessarily say, hey, look, I could settle this case for $5,000 inclusive, but you're going to pay me $10,000 to try it. They were billing. It was a law firm that had a billable hour requirement. These attorneys were being paid by the hour. They wanted to go, they wanted to arbitrate, they wanted to depose, they wanted to inspect, they wanted to try because they were able to bill for it. And they were more than happy to litigate these cases. And I think the car manufacturer just didn't have that much of an auditing process and didn't realize they were being taken for a ride by this firm and how much money they were throwing at this firm to handle their cases. So if I had a client say to me, well, they're not really going to want to try it, right? That's going to cost them too much money. It's actually on the contrary and the opposite. Oh, no, they want to try it because their attorney is going to bill for this and he's going to have his expert sitting there for 3 days and he's going to bill for that and he's going to bill as much money as he can.
I was going to say, and in their defense, which Courtney, this is killing me to say, they were a formidable opponent, I have to say. Those were some of the hardest arbitrations, most frustrating arbitrations, longest arbitrations. I'm talking 2 to 3 hours that we were in that arbitration room when on average it's like 1 hour litigating these cases with us. So yes, they were billing, and I do agree with you. I think that sometimes too they had money from the because they had approval, I think, to settle claims and they chose not to, which is to their discretion. I do think they have some freedom there, but I have to say they were tough. Those were the arbitrations that I prepped for the most. Like I would pore over the documents. Not that I don't for every arb, but you know what you're up against when you're against certain manufacturers. You know who's going to be there. You know if their expert is coming. You know if they're not. And you can prepare accordingly. Those are tough arbitrations. Those are really tricky because they always somehow found something that they could try to use against our client that they didn't tell us about in advance. And so you had to be on your toes and ready for anything in those arbitrations. Fortunately, they've since changed course and don't really use that firm very much anymore. But those were tough. And I don't think clients were expecting that either, honestly. I think they went in there and they didn't realize what they were going to be up against.
Yeah. Oh, 100%. They were absolute dogfights. And those were a lot of the arbitrations that I would walk out of and our clients would just be flabbergasted because they thought they were going to walk in and feel vindicated and be able to talk and explain their side. And instead they were almost just shut down. And you've got an attorney on the other side who is, I won't say lying, sometimes lying, but at the very least bending the truth. And it's coming off badly for our client. And there's only so much that you can do. And for the most part, you're just sitting there and having to listen to it. And the arbitration panel is listening to it. And yeah, you do get a rebuttal and you get to explain, but it doesn't take away what they've said. And it would often be this attorney on the other side that was a big, booming man with a big, booming voice. And he was hostile and he was aggressive. And it was not fun.
Yeah, it can be really tricky and really difficult. And that's why I think kind of to bring it all sort of full circle and bring it back after we've kind of told our war stories here about going to trial is that the pre-litigation offers that we receive, I think that's why it's so important to have an attorney to help you evaluate whether this offer is decent enough to take or acceptable to take, because a lot of our clients, and rightfully so, they're passionate, right? And they are furious. They are so upset that this vehicle that is a very costly item is not functioning the way that it should. And I think that's why it's so important to have an attorney to kind of lay all the cards on the table and be like, listen, I know you're frustrated. I know you might be a little disappointed in this number. And that's not to say we don't have the reverse of that, right? We have clients that are enthusiastic, that are thrilled with what we get. We're just talking about the scenarios in which the client's frustrated and they don't want to accept it and they want to go to court. That's why it's so important to have an attorney to be able to tell you this is what it's going to be like. This is what you're going to experience. This is not an episode of The Good Wife, right? Like this is what real litigation is like. And that's why an attorney is so important, not only to help you know what trial is going to be like, but to assess what the offer is, right? How many clients demanding repurchases when they don't qualify under the Lemon Law? And then they don't realize that breach of warranty will only get you X, or that there's no pain and suffering or things like that that can be included as well. And that's why attorneys are so important to have when you're going through this type of a scenario.
I would say one other aspect to take into consideration is not even litigation or pre-litigation, but hey, we were able to successfully resolve your case and you are going to get that repurchase. That too takes time. People don't realize it, but repurchases do not happen the day that you accept the settlement. For example, Kia is notoriously slow when it comes to a repurchase. It can take anywhere between 90 to 120 days. at best. And we can ask them all day long, can you hurry it up? Can you hurry it up? Unfortunately, they have to process. They bring in a third party to help them coordinate this. So clients will get frustrated even with the settlement. So you have to understand every manufacturer does have their own process for a repurchase or a cash settlement or a replacement when that does take place. But you need to remember, we are working to try to get those settlements done as quickly as possible, but we can't control their internal process as well.
Which is true, absolutely. But at the same time, right, we have some tricks up our sleeve too that we can use that the average person wouldn't be able to, right? Most clients, they call us if they've dealt with the manufacturer's customer care first, they're super frustrated because they keep calling the same person and getting their voicemail. They don't get calls back. They don't get emails back, or they keep moving case managers, right? I was with this person, now I'm with that person. I have to go through the whole story again. I've got to send all my repair orders or my receipts over again. Whereas, or even in the event of the Kia repurchase, they're just going to keep calling, right? Just keep calling that same person and not really getting anywhere. Whereas us with attorneys, not only one, do we know most of the people over at that group, right? So we've done it before where I just start adding people from Kia, for example, to an email and just add enough people complaining and kicking and screaming about getting something done that eventually it makes its way to a supervisor and they get back in touch with us. Or like something that Courtney and I just had to deal with, what was it, yesterday? We had a Kia repurchase that was accepted in September. It is now April 8th, and nothing has happened yet. So we have their outside counsel. So basically, when a lawsuit's filed against Kia, they have a law firm that they use to defend them. We know that law firm. We know the attorney there. I mean, our kids used to go to daycare together. Like, I know who he is. And so we did end up filing a motion against Kia like probably a year or two ago now on these repurchases that took too long, which again, another card we have up our sleeve that the average consumer can't do. We can file a motion to enforce the settlement with court in order to push it through and get something done. And basically, once that was resolved, he reached out to me and said, no motions, please call me. I'll handle it. Let me know what you need and I will fix it for you. Courtney just followed up with them yesterday saying, hey, we really need this repurchase pushed through. Literally within 24 hours, the client got a call from Morley, which is that third party you referred to set up the surrender. There are tools that we have that we can use that the average consumer can't to push these claims through and to get the manufacturer's attention that the average consumer just simply doesn't have. So it's another, important reason to use an attorney to help push your timeline along, because otherwise you're just sitting there making phone calls and not getting anywhere. But in preparation for these claims, there are things that consumers can do to make our jobs easier so we can make it go faster. And the main thing is to have all your documents, which we've said before and we'll say it again, right? Have your purchase agreement, keep all of your repair orders, and make sure that you have them readily accessible to be able to send over to us. Because most manufacturers don't even start their review process until they have all the documentation from us. Because they're not going to share their internal information with us, right? It's our responsibility. We're the ones who are bringing the claim. So we are the ones who are responsible for providing the evidence. So when our client says, hey, I've got a whole zip drive with all my documentation on it, I always joke with them and tell them that they've just become my favorite client because that's just what makes the case so much easier to have everything readily available for us to send over to them. And if we get the denial or we get a low offer, again, we have all the information that we need to review the case for litigation so we can have an informed conversation with the client about what litigation would look like, what we are up against, instead of just going off the history that they gave, which we don't know if we can prove in court or not, right? We have some cases where we've gotten the denial, but we don't have all the docs from the client. They're not really being responsive, or they're, dragging their feet going to the dealership to get them. So the case is just sitting. Because we're not going to file a lawsuit on a case that we don't have the documentation for or some sort of proof or evidence that we have a viable claim to push it forward.
Yeah, absolutely, Emma. I have so many clients who maybe the registration has expired and they're dragging their feet on re-registering the vehicle, and we can't do anything without a valid registration. Even once we settle the case, opposing counsel, the manufacturers won't send us the releases until we send them a valid registration. So we're just at a stopping point there. So having that registration, having those repair invoices, having your purchase agreement, absolutely helps to speed the case along because, like you said, sometimes these cases are just sitting and waiting for those documents. So definitely try to have those things, have your ducks in a row before contacting us or get them in a row right after contacting us, and it's absolutely going to speed the process along.
I totally agree. And with that, I think we've covered all of our bases here. I think the long and the short of it is that lemon law claims can really vary in terms of how long they take. And a lot of that factor, I think, does hinge on whether we have all the proper documentation from our client and whether we have all of our ducks in a row to be able to push the case forward and be able to really drive it home that we have a valid claim here and we need a remedy. And with that, we want to thank you for listening. As always, please feel free to call our intake line if you think that you may have a lemon at 833-4CAR-LAW. You can also visit our website, lemonlawcar.com, for more information on the lemon law in your state and how we can help.
Lemon Law Unpeeled is for informative purposes only. It is not to take the place of legal advice and does not create an attorney-client relationship between the viewers and Robison Lemon Law Group. Individual results also may vary as outcomes are determined on a case-by-case basis.